today we will be talking about the DMA. The DMA is a core area of practice for my firm, Girardin Partners. We like to say that we have three pillars in our practice. One is competition law, the second one is tech regulation, and the DMA and the DSA and the DMCC in the UK are, of course, key pieces of legislation for us and our clients, and then competition litigation. It's also a core area of reporting for the Capital Forum, our partner in this event, and I very often discuss the DMA with my friend Javier Espinoza, who's around and will be the other master of ceremony, if we could say so. I think the conference is quite timely for several reasons. As you know, gatekeepers had until March 2024 to bring their practices into compliance with the DMA. That means that it's almost 2 years ago. Quite a bit has happened since then, and I think it's a good moment to take stock of where we are with the DMA. Some have said that the DMA has not achieved much. Others said that the DMA is too intrusive. So I'm sure we'll hear different voices today. As far as I'm concerned, I'm not surprised that it takes a bit of time to achieve results with the DMA. A lot of clients thought that everything would be over by the 7th March 2024. I always told them it was the beginning of the process, not the end of the process, because a piece of legislation is not worth very much until it has been fully implemented. So today we have 4 panels that will cover a lot of ground. I think the first panel is really a panel to discuss where we stand with the DMA, the level of compliance, the remaining problems, and so on and so forth. The second panel will deal with mobile ecosystems and the DMA. This is obviously a very hot topic. You have quite a bit of enforcement with respect to the DMA and Apple, as you may know. And then the third panel will be about AI. I mean, AI is, of course, something that has become increasingly important. One of the dangers, of course, with sector-specific regulation is that it may be outdated by the time it is implemented. And, of course, AI is bringing new challenges. And one of the questions is that the extent to which one can use the DMA in order to deal with some of the issues that have emerged from AI. The final panel is private enforcement. As you know, private enforcement was minimal in Europe for a long time, but now you see a lot of it. You see a lot of damages litigation, an area in which we're very active, as you may know. But you may also have, traditional litigation, one company against another. And one of the things that is really interesting with the DMA is that it has direct effect. It's a regulation, which means that any company can go to court in order to demand that the DMA be complied with. And I think what we'll see going forward are more actions related to the DMA. We are already seeing some in Germany. I think a lot of companies are waiting to see what will be achieved by the Commission, this year and next year, and then if there are areas, remaining areas of non-compliance, I think some of them will take their luck in court. I think we'll see a lot of also damages action that will be hybrid. That means that it will be partly based on competition law and partly based on the DMA. So I think it's an area to watch. I think private enforcement is very exciting in the DMA space, and this is why we have a panel on this topic. I hope you will have a wonderful day of discussion. Don't hesitate to ask questions to the speakers. I hope there will be enough time for Q&As. Now, I have the great pleasure to introduce our keynote speaker, Ian Forrester. Ian is one of the greatest competition lawyers of our generation. He's had a brilliant career. He's done lots of different things. First of all, he founded one of the very first competition law boutiques in 1981. That boutique merged into White & Case a few years later, and Ian was, of course, the leading figure in White & Case EU competition practice. Ian handled some of the most famous competition cases. He argued McGill for the European Commission, then IMS, and he was also involved in Microsoft. So these cases were among the most influential in areas such as, for example, refusal to license or refusal to supply, and tying and bundling. Then Ian was appointed at the General Court as a UK judge, where he stayed a number of years, and then finally Ian is a member of the Competition Appeal Tribunal in the UK. Ian is a wonderful person. He's always nice to be with, a true gentleman, with a great sense of humor. So hopefully you'll share a bit of your humor with us today, Ian. And I think Ian is particularly well placed to explain how and why we got from competition law to sector-specific regulation. It's perhaps one of the topics that you'll deal with in your presentation. So thank you very much, everyone. Thank you very much, Ian. And the floor is yours.
What Damien didn't mention is that I hold a really proud record in that I was the first lawyer on earth, the fines upon whose clients exceeded 3 billion euros. And I think that is an achievement that exactly deserves proper recognition. When Jeremy Jourdan and Damien contacted me about this event, I was a little hesitant because I said I don't, in a daily way, deal with the DMA. And they said, well, it's okay, we'll educate you. And I thank Jeremy for bringing me up to speed about what is actually cooking. I suggested that it's interesting always to start with history. I was speaking at Fordham in New York 2 weeks ago, and my talk was entitled From the Black Death to Google Shopping, Evolution of Competition Policy Over the Centuries. And I think that it is good to realize that the DMA doesn't exist, as it were, in a vacuum. It's the consequence of years of involvement by the public authority in the marketplace, using different techniques, using different theories. And the relevance of the Black Death is that in 1349, after a plague greatly diminished the workforce in Europe, there was inflation. And King Edward III said in the Statute of Labourers in 1349, if you're able-bodied, man or woman, you have to go back to the job you had before the plague, and you have to accept the same pay. And that remained in force for centuries, although I don't think it was a great success in combating inflation. So that history, excuse me for a second, just in case that was me, that history moving rapidly forward. I started practicing competition law in Brussels, I'm ashamed to say, in 1972. And I was an observer of the small number of competition cases which were taken in those days by the European Commission. Competition decision-making was slow, perfectionist, and individual decisions were not really punishments of misconduct. To a degree they were, but they were also, and perhaps more importantly, flagship rule-making opportunities for the European Commission. And every case was examined with great care. There were sometimes only 8 or 9 or 10 decisions in a year. And equally, judicial review in Luxembourg was a celebrity occasion. And I remember attending my first, which I think was commercial solvents, just looking at the case to go forward. So, the policies which were pursued by the Commission in those early days were dominated by market integration. The European institutions wished to achieve market integration, and obstacles to parallel trade were the constant target of the European Commission. More fines were imposed in those early days. They lasted 30 years, for contractual hindrances to parallel trade than anything else. Similarly, when it came to trade wars with Japan, the voice of the competition team in the European Commission was heard saying, careful, 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 we're too enthused about anti-dumping measures. Actually, they may not help European industry because they protect against normal competition, healthy competition. Beware of what you wish for. So another feature of the old days was DMA made a distinction between public and private enforcement. So during those days, the European Commission was public enforcer, and it operated a kind of fiction, which was that only the Commission could grant approvals of agreements which were, they had this, but they had that, how to balance. And the Commission was the only source, not national authorities, not national courts, even though there was direct effect for the competition rules, it was the Commission that had the monopoly on interpreting and applying the rules, and above all, granting approval under 85.3. Now, those phenomena continued until 2004 and the big explosion when the Commission gave up its monopoly over, in effect, the interpretation of Article 101 and shared that former monopoly with national authorities and national courts. So the enforcement of the competition rules went through a massive change. And we see today, and I'll say a bit more later, how that has affected the diet of cases pending before the General Court and the Court of Justice. But let's go back a little bit to the oldest cases, not the oldest cases, the early cases on abuse of a dominant position. The old cases, the early cases, let's say, we're not old, the early cases of abuse of a dominant position usually involved, and I used to say to students, a moral breach. That's to say, the big bully doing something nasty to someone smaller. That was a moral element in the decision on whether to pursue a case. Now, one nice example in which I was a little bit involved was Hilti. And there, the manufacturer of nail guns said you can only use our nails because you can't use any competing nails, that was an old-fashioned tying, bundling abuse. Now, I don't know what really the facts were, but the defense of the bundling obligation just didn't seem persuasive. And so all of these, as I say, early cases involved a bit of abusive thuggishness. That's an extravagant word which you won't understand, right, stop there. There came, however, cases, one case and then another case, which related not to bad behavior, but rather to design. And my old mentor, David Edward, and Nicholas Forwood, and Jeremy Lever, giants of the bar, were involved in defending IBM. Now, IBM was trying to maintain its massively successful position with respect to mainframe computers. And the question was, to what extent could IBM be compelled to tolerate the presence in its network of, for example, printers made by rival enterprises? And you'll not be surprised to hear that there were predictions of doom and catastrophe if a Fujitsu printer could be plugged in to an IBM mainframe. Planes would crash from the sky. You just couldn't be sure what would happen. So it was a bit about design and a bit about intention. And then come to the Microsoft case. There were two cases, two big cases against Microsoft in those days. One in the United States, and in the United States, Judge Jackson, I think it was ordered Microsoft to be split in two. There was an appeal. His decision was reversed. The case was given to another judge. And interesting for today's topic, the other judge said, guys, this is hellish complicated. Go into a hotel room and don't come out until you've reached a settlement. And 1 million pizza slices later, after 6 weeks, I don't remember, and I wasn't involved in those discussions. But at the end, woof, the stupefied, exhausted negotiators emerged. There had been a settlement. Now, in Europe, there were two design-related infringements which were ultimately retained by the European Commission. And one of them, that's to say, there were 3 statements of objections as the theories of the Commission evolved and different new accusations were made and old accusations were discarded. So the first infringement was the inclusion, you can call it bundling, or you could call it offering the consumer something richer and better for the same price, of a media player. Until then, Microsoft had procured from an independent outfit a media player and included that in Windows. And then Microsoft was developing constantly new features. In the oldest days, a computer could make a beep, and then a computer could handle only black and white, then it could handle color, then it could be sound, then it could be stereophonic sound, then it could be et cetera, et cetera. So the history from the Microsoft point of view was, this is a really good product, we're making it better and better and better all the time. Now, from the point of view of the dependent industry, they saw, and this was my image, they saw the lava coming down the mountain threatening them. And Microsoft said, well, we don't want to threaten you. And they'd say, yeah, but you're going to put us out of business. So the Microsoft inclusion of the media player was one of the two infringements. And the second one was not revealing in a Windows Server network the data necessary to permit Sun or other competitors to perform in that network as if it were a Microsoft server. And that was a question of compulsory licensing. And the two remedies were also interesting, a bit curious, one might unkindly suggest. One, with respect to the media player, the remedy was to bring out a new product, and the new product would be Microsoft Windows without media functionality at the same price as Microsoft Windows with media functionality. Now, it will not amaze you that 35 million copies of one and 1,500 copies of the other were actually sold. I have, I'm proud to say, one copy on my wall of Windows XP N for not with media functionality. So that remedy didn't work very well. The Commission has an answer, which is if Microsoft had left the unimproved version on the market, maybe that would have alleviated the damage to other competing media players. And the second one was obliging Microsoft to license would-be licensees, not with a copy of the software underlying participation in a Windows network, but a description of how that software worked, and in order to avoid copying and cloning. So that also led to controversy about the quality of the licensed material and so on. So why am I telling you all this? Of course, I was involved, and it's very sharp in my mind. It was a fascinating forensic experience. But it is, I think, the case which led ultimately to what we're now talking about, the DMA. Let me say, by the way, that I am here on behalf of no one except myself. I am a member of the Competition Appeals Tribunal. I'm certainly not speaking on their behalf. I'm a member of the bar, and I'm giving my own views and no one else's. So we can see, as I say, two themes in the Article 102 abuse of dominance case law, cases. One is the notion of bad behavior, and the other is the design, the structuring of how the marketplace works. A couple of other points worth noting as a feature of where we were prior to the adoption of the DMA, let me say during the period up to 2015, maybe, when I went on the court. Delay, a terrible, terrible problem in the field of competition. On the one hand, there's due process. On the one hand, obviously, that involves a duty to inform the alleged infringer of the case against. That's a duty to give access to the file. That's a duty to consider every point made by both sides. And at the end of the case, there will be a pile that high saying no, and a pile that high saying yes. Now, considering these fairly necessarily involves a huge amount of time. The Commission wants to be thorough. The Commission is nervous about judicial review. The Commission doesn't want to omit any point that has been the subject of controversy, and so everything is dealt with thoroughly. And that leads to decisions of 500 pages. A decision of 500 pages is very, very difficult to do judicial review effectively. And the danger is, which the court is perfectly aware of, is that the issues of principle may not, they risk being insufficiently considered if the court just looks at questions of procedure, timing, access to the file, deadlines, and so on. So that's a phenomenon in a democratic society where judicial review is an intrinsic and important part of how decisions in competition or any other matter are taken. Another point, so I'm telling that because it is a problem in a prosecution regime where individual decisions are punishments or are oriented towards punishing bad behavior. That was the structure of the applicable basic regulation. Similarly, enormous, gigantic fines. My first fine was for hindering the export of Rolling Stone records from Paris to Brussels. A commission official, the lovely Dr. Johannes, wanted to buy Rolling Stone records for his daughter. The shopman said, sorry, I wish I could sell these in Brussels. If the prices are higher there, I wouldn't mind, but I'm not allowed to. It's contrary to the law. And Dr. Johannes said, would you like to write a little complaint? Yeah, sure. And 9 months later, a fine was imposed for the infringement. Now, 45,000 euros, that's the price of a coffee these days. I exaggerate slightly. Coffee with a croissant, perhaps. And now we're talking of gazillions. The fining policy is striking, extraordinary. The fines have now, I think, reached 7 billion with a B, and I think there's probably in the world no crime, economic or otherwise, that attracts higher fines. So let's go forward. When I was on the court, there were a number of Google cases. For example, self-preferencing. In a very primitive way, if you wish to consult Google about Korean restaurants in Heidelberg, the search result would, in those days, give a better prominence to Korean restaurants which had paid to advertise with Google. You might say to yourself, well, that's not surprising. You might say to yourself, that is shocking. So those cases came under the old pre-DMA regime. Now, some of you, I'm sure, here present will bear the battle scars of those cases, so I'm not going to pretend to offer insightful comments. But I remind you that the Commission was faced with the problem of punishing slowly, lately, if you can say that, in arrears, anti-competitive conduct. At the same time, there would be very intense discussions with the companies involved. And the companies would say, but, and but, and but, and the complainants would say, no, no, no. So making those decisions was a big challenge, and it must be the case, and maybe we'll hear reminiscences from those involved, it must be the case that the delay between the challenge conduct and the final judicial review of the decision condemning that conduct was very, very long. So, reaching a settlement in a competition case is, I suggest, almost always better than not reaching a settlement. So to a degree, to a big degree, the institutionalization through the DMA, forcing parties to meet each other and to discuss, not in the framework of a prosecution, but in the framework of a debate between opposing parties. I think, I hope, that that is a step forward. Now, a curious, unexpected consequence of the shift in priorities to get the DMA running, I've been told that there's something like 300 new faces in DG competition working on the DMA. That has meant that the enforcement of competition law, public and private, has moved, following the explosion of 2004, to national courts and national authorities. There are far, far more national competition cases than there used to be. Not that there were none, but there are far, far more nowadays. For example, the supermarket says, I'll invest in your shopping mall, but only if I'm only if I have exclusivity. Is that a restriction of competition? Some questions referred to Luxembourg rather easy, some questions really quite complex. So a consequence of the shift of responsibility is that there are fewer appeals pending on competition matters before my old court. When I joined the court, there were quite a number. When I left the court, there were interesting cases like Lithuanian Railways and a bunch of intriguing cases before the court. But today, the great majority of interesting pending matters in Luxembourg are pending before the Court of Justice. So one of the difficulties, challenges for the courts is, I say it again, prolixity. 500 pages of decision on matters great and small. That is a very, very difficult challenge for the court to make sense of. It's even a difficult challenge, and you know it very well, to frame your criticism, your challenges to the court within 72 days, the deadline, in a way to explain to the judges what really is at stake, the big points and the small points. So, what I see as a hopeful trend is that the nationalization, a word, of competition law before national authorities and national courts may lead to more jurisprudence coming from Luxembourg and more guidance to everyone. I think that's a positive. I also note that there's a growing number of national class actions where a law professor, an environmental professor, an ordinary citizen, different people bring sophisticated claims against a big enterprise, a water company, or Google, or Amazon, saying, a very interesting theory of harm. And those cases are involve sometimes the certification, that's to say, the blessing of the case brought by the individual on behalf of millions of other people. So there will be a surge of national court examinations of national authority examinations of very interesting and sophisticated claims made by individuals. So, where I see it's 10 o'clock and 1 minute, what are the concluding elements that I'd bring to you? The idea of structuring antitrust enforcement to achieve better design of complex high technology structures and platforms on the basis of round table debate seems to me structurally more likely to lead to satisfactory outcomes and settlements. In my personal experience, settlements like treaties, they may be exhausting and they may disappoint everyone, but they are better than continuing to make war. That's one thought. Second is, as a matter of procedure, it must be important for the civil service involved not to approach things as a prosecutor, but rather as a regulator. That's to say, not looking for guilt, but rather looking for how can we make things work better. And that has a consequence, and this is my last point, that has a consequence for judicial review. If you are, the one example, supposing that there is a disabled child. Question, is the child sufficiently disabled to be eligible for a free bus pass? The person who does that inquiry, if they have acted fairly, will normally take a decision neutrally, and it will be very unlikely that a judge would say, you got the wrong conclusion. Similarly, with respect to the decisions of the DMA, it might be, I speculate, that the level of deference which would be expected from a court vis-à-vis a public authority which is expert, it's possible that the level of deference would be different. That's an important point, and let me repeat what I've said. Where there is a prosecution and the imposition of fines under the Human Rights Convention, a quasi-criminal environment, when that is the case, there is a duty upon the court under Menarini, under Halkor, which I argued, to conduct a review of fact and law in principle complete. So deference in quasi-criminal matters is inapplicable. In a regulatory matter, the conclusions reached after a fair process where all sides have been heard and one would hope contradictoirement heard, it may be that a different level of respect by the judge by the court for the conclusion reached by an expert authority would be different, would be more respectful, there would be more reluctance to second guess the conclusion of the regulatory authority. Now, the DMA has been with us for 2 years, I think. Where do we stand? I think the truthful answer is, well, in my case, I don't know yet, but I think that events like this are an absolutely splendid way of examining the procedures by which the DMA is applied and the substance within which decisions are made by the European Commission. I would hope that in 2 years' time, we will see that there is a more optimistic atmosphere, and I take out more optimistic. I would hope that there is a positive atmosphere relating to how the DMA is interpreted and applied, and having an event like this is a splendid way of keeping us thinking, and thank you for inviting me.